Good day, everyone. Today we are discussing about Law of Corporation, which are Title 5, Bylaws, Title 6, Meetings, and Title 7, Stock and Stockholders.
Section 45. Adoption of Bylaws. For the adoption of bylaws by the corporation, the affirmative vote of the stockholders representing at least a majority of the outstanding capital stock, or at least a majority of the members in case of non-stock corporation, shall be necessary. The bylaws shall be signed by the stockholders or members voting for them and shall be kept in the principal office of the corporation, subject to the inspection of the stockholders or members during office hours. A copy thereof, duly certified by a majority of the directors or trustees and countersigned by the secretary of the corporation, shall be filed with the commission and attached to the original articles of incorporation. Notwithstanding the provision of the preceding paragraph, bylaws may be adopted and filed prior to incorporation. In such case, bylaws shall be approved and signed by all incorporators and submitted to the Commission, together with the articles of incorporation. In all cases, bylaws shall be effective only upon the issuance of the Commission of a certification that the bylaws are in accordance with this code. The Commission shall not accept for filing the bylaws or any amendment thereto of any bank, banking institution, building and loan association, trust company, insurance company, public utility, educational institution, or other special corporations governed by special laws, unless accompanied by a certificate of the appropriate government agency to the effect that such bylaws or amendments are in accordance with law.
Section 47. Contents of Bylaws. Subject to the provision of the Constitution, this code, other special laws, and the Articles of Incorporation, a private corporation may provide in its bylaws for: number 1, the time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. Number 2, the time and manner of calling and conducting regular or special meetings of the stockholders or members. Number 3, the required quorum in meetings of stockholders or members and the manner of voting therein. Number 4, the form of proxies of stockholders and members and the manner of voting them. Number 5, the qualifications, duties, and compensation of directors or trustees, officers, and employees. Number 6, the time for holding the annual election of directors, of trustees, and the mode or manner of giving notice thereof. Number 7, the manner of election or appointment and the term of office of all officers other than directors or trustees. Number 8, the penalties for violation of the bylaws. Number 9, in the case of stock corporation, the manner of issuing stock certificates. And the last, number 10, such other matters as may be necessary for the proper or convenient transaction of its corporate business and affairs. Section 48. Amendments to Bylaws. The Board of Directors or Trustees, by a majority vote thereof, and the owners of at least a majority of the outstanding capital stock or at least a majority of members of a non-stock corporation at a regular or special meeting duly called for the purpose, may amend or repeal any bylaws or adopt new bylaws. The owners of 2/3 of the outstanding capital stock or 2/3 of the members in a non-stock corporation may delegate to the Board of Directors or Trustees the power to amend or repeal any bylaws or adopt new bylaws, provided that any power delegated to the Board of Directors or Trustees to amend or repeal any bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or a majority of the members in non-stock corporation shall so vote at a regular or whenever any amendment or new bylaws are adopted, such amendment or new bylaws shall be attached to the original bylaws in the office of the corporation, and a copy thereof duly certified under oath by the corporate secretary and a majority of the directors or trustees shall be filed with the Securities and Exchange Commission, this same to be attached to the original articles of incorporation and original bylaws. The amendment or new bylaw shall only be effective upon the issuance by the Securities and Exchange Commission of a certification that the same are not inconsistent with this code.
Title 6 Meetings. Section 49 Kinds of Meetings. Meetings of directors, trustees, stockholders, or members may be regular or special. Section 50 Regular and special meetings of stockholders or members. Regular meetings of stockholders or members shall be held annually on a date fixed in the bylaws. Special meetings of stockholders or members shall be held at any time deemed necessary or as provided in the bylaws. Whenever for any cause there is no person authorized to call a meeting, the Securities and Exchange Commission, upon petition of a stockholder or members on a showing of good cause, therefore may issue an order to the petitioning stockholder or member directing him to call a meeting of the corporation by giving proper notice required by this code or by the laws. Section 51 Place and time of meetings of stockholders or members. Stockholders or members meeting, whether regular or special, shall be held in the city or municipality where the principal office of the corporation is located, and if practicable, at the principal office of the corporation, provided that Metro Manila shall purpose of this section be considered a city or municipality. Notice of meetings shall be in writing, and the time and place thereof stated therein. Section 52. Quorum in meetings. Unless otherwise provided for in this code or in the bylaws, a quorum shall consist of the stockholders representing a majority of the outstanding capital stock or a majority of the members in the case of non-stock corporations. Section 53. Regular and special meetings of directors or trustees. Regular meetings of the board of directors or trustees of every corporation shall be held monthly, unless the bylaws provide otherwise. Special meetings of the board of directors or trustees may be held at any time upon the call of the president or as provided in the bylaws. Meetings of directors of or trustees of corporations may be held anywhere in or outside of the Philippines, unless the bylaws provide otherwise. Notice of regular or special meetings stating the date, time, and place of the meeting must be sent to every director or trustees at least 1 day prior to the scheduled meeting. Section 54. Who shall preside at meetings? The President shall preside at all meetings of the directors or trustees, as well as of the stockholders or members unless the bylaws provide otherwise.
Section 55. Right to vote of plegors, narrators, and administrators. Plegor or narrators have the right to attend and to vote. Executor or administrator has the right to vote shares belonging to the estate of his decedent. Section 56. Voting of shares yield jointly. If shares are owned by two or more persons jointly, the right to vote is in them jointly, and in order that the shares may be voted, they must agree upon the vote. This rule of joint action applies to share yield by several executors or trustees. Section 57. Voting right for treasury shares. Treasury shares shall no voting right as long as such stock. Section 58. In corporate law, a proxy is the person who votes for the trust representative that stakeholders or members. Ordinarily, the right to vote shall be exercised by stakeholders themselves or by their duly authorized representative. The growth of corporations has made it necessarily to delegate voting power to someone else. Section 59. A voting trust is an agreement by which stakeholders surrender their voting power and place it in the hands of others for a definite period of time. It makes possible unified control of the affairs of the corporation and a consistent policy, and allows a majority group of shareholders to dispose a beneficial interest in a large proportion of their shares and still retain control.
Title 7. Stocks and Stockholders. Section 60. Subscription contract means that any contract for the acquisition of an issued stock in an existing corporation or a corporation still to be formed shall be deemed a subscription within the meaning of this title, notwithstanding the fact that the parties refer to it as a purchase of some other contract. Section number 61. Pre-incorporation subscription means that a subscription for share of stocks of corporations still to be formed shall be irrevocable for a period of at least 6 months from the date of subscription, unless all the other subscribers consent to the revocation or unless the incorporation of said corporation fails to materialize within said period or within a longer period as may be stipulated in the contract of subscription, provided that no pre-incorporation subscription may be revoked after the submission of the articles of incorporated to the Securities and Exchange Commission. Section number 62. Considering for stock. Stock shall not be issued for a consideration less than the part issued price. Therefore, consideration for the issuance of stock may be any of or a combination of any two or more of the following. Number 1, the actual cash paid to the corporation, and number 2, property, tangible or intangible, actually received by the corporation and necessary or convenient for its use and lawful purposes at a fair valuation equal to the par or issued value of the stock issued. Number 3, labor performed for or services actually rendered to the corporation. Number 4, previous incurred indebtedness of the corporation. Number 5, amounts transferred from unrestricted retained earnings to stated capital. And last, number 6, outstanding shares exchanged for stocks in the event of reclassification or conversion, where the consideration is other than actual cash or consists of intangible property such as patents of copyrights. The valuation thereof shall initially be determined by the incorporators of the board of directors, subject to approval by the Securities and Exchange Commission. Shares of stock shall not be issued in exchange of promissory notes or future services. The same consideration provided for this section, insofar as they may be applicable, may be used for the issuance of bonds by corporation. The issued price of no par value shares may be fixed in the article of incorporation by the board of directors pursuant to authority conferred upon it by the articles of incorporation or the bylaws, or in the absence thereof by the stockholders representing at least a majority of the outstanding capital stock at a meeting duly called for the purposes. Section 63. Certificate of stock and transfer of shares. The capital stock of stock corporation shall be divided into shares for which certificate signed by the president or vice president, countersigned by the secretary or assistant secretary, and sealed with the seal of corporation, shall be issued in accordance with the bylaws. Shares of stock so issued are personal property and may be transferred by delivery of the certificate endorsement by the owner of his attorney in fact or other person legally authorized to make the transfer. No transfer, however, shall be valid except as between the parties until the transfer is recorded in the books of the corporation, showing the names of the parties to the transaction, the date of transfer, the number of the certificate or certificates, and the number of shares transferred. No shares of stock against which the corporation holds any unpaid claim shall be transferable in the books of the corporation. Okay, number 64, issuance of stock certificates, means that no certificate of stock shall be issued to a subscriber until the full amount of his subscription, together with the interest and expenses in case of delinquent shares, if any is due, has paid. Okay, last section 65, liability of directors for watered stocks, means that any director or officer of a corporation consenting to the issuance of stock for a consideration less than its par or issued value, or for a consideration in any form other than cash, valued in excess of its fair value, of or who, having knowledge thereof, does not forthwith express his objection in writing and file the same with the corporate secretary, shall be solidarily liable with the stockholder concerned to the corporation and its creditors for the difference between the fair value received at the same time of issuance of the stock and the par or issued value of the same time. Section 66. Payment of balance subscription. Subject to the provision of the subscription contract, the board of directors may at any time declare due and payable to the corporation unpaid subscription, and may collect the same or such percentage hereof in either case with accrual interest, if any, as it may deem necessary. Section 67. Delinquency sale. When does the stock become delinquent? A stock become delinquent upon failure of the holder to pay the unpaid subscription of balance thereof within 30 days from the date special in the contract of subscription or on the date stated in the call. Section 68. When the sale may be questioned, no action to recover the liquid stock sold can be questioned upon the ground of irregularity or defect in the notice of sale, in the sale itself of the delinquent stock, unless the party seeking the maintains such action first pays or tenders to the party holding the stock the sum for which the same was sold, with the interest from the date of sale at a legal rate. No such action shall be maintained unless a complaint is filed within 6 months from the date of sale. Section 69. Court action to recover unpaid subscription. Nothing in this code shall prevent the corporation from collecting through court action the amount due on any unpaid subscription with accrued interest, costs, and expenses. Section 70. The effect of delinquency. No delinquent stock shall be voted for, be entitled to vote, or be represented at any stockholders' meeting, nor shall the holders thereof be entitled to any of the rights of the stockholder except that right to dividends in accordance with the provisions of this code, until and unless payment is made by the holder of such delinquent stock for the amount due on the subscription with accrued interest and the cost of expenses of advertisement if any.
Section 71, talking about the effect of delinquency. No delinquent stock shall be voted for, be entitled to vote, or be represented at any stockholders' meeting, nor shall the holder thereof be entitled to any of the rights of a stockholder except the right to dividends in accordance with the provisions of this code, until payment is made by the holder of such delinquent stock for the amount due on the subscription with accrued interest and the cost and expenses of advertisement. Section 72. The rights of unpaid shares, non-delinquent. Holders of subscribed shares not fully paid, which are not delinquent, shall have all the rights of stockholders. For example, for these sections is that the unpaid shares or overdue payments. Section 73. Lost or destroyed certificates. These are the following procedures shall be followed by a corporation in issuing new certificates of stock in lieu of those which have been lost or destroyed. First, the registered owner of a certificate of stock in a corporation or such person's legal representative shall file with the corporation an affidavit in triplicate setting forth, if possible, the circumstances as to how the certificates was lost or destroyed, the number of shares represented by such certificate, the serial number of the certificate, and the name of the corporation which issued the same. Second, after verifying the affidavit and other information and evidence with the books of the corporation shall publish a notice in a newspaper of general circulation in the place where the corporation has its principal office, once a week for 3 consecutive weeks at the expense of the registered owner of the certificate of stock which has been lost, stolen, or destroyed. The notice shall state the name of the corporation, the name of the registered owner, the serial number of the certificate, the number of shares represented by such certificate, and shall state that after expiration of 1 year from the date of the last publication, in lieu thereof, the corporation shall issue a new certificate of stocks unless the registered owner files a bond or other security as may be required, effective for a period of 1 year, for such amount, and in of directors, in which case a new certificate may be issued even before the expiration of 1 year. Period provided herein. Thank you.